right, the next case is Blake versus Bayfront Medical Center.
Good morning, Your Honors. Roy Watson, representing the appellants. With me, Marjerie Chalant, co-counsel. And I'd like to reserve 5 minutes for my rebuttal time.
All right.
And I think it's wise to address initially the jurisdictional argument that we received an order last week concerning why this court has jurisdiction over this partial final order under the standards established by the Universal Underwriters case, which I know Judge Wallace was on that panel back in 2013. Three factors under the Universal Underwriters case that the court should take into consideration in determining whether an order is a partial final order that is appealable. I'm going to take them in reverse order if possible. The third factor, are the counts separately disposed of based upon the same or different facts than the counts that are remaining? And here they are much different facts. To begin with, there's facts in two categories. There's the facts pertaining to the relationship between the negligent actors and the hospital. And second, there's the facts pertaining to the negligence, the liability of those negligent actors.
Mr. Watson, don't all these facts arise out of the same interrelated set of events which involve this gentleman's admission to the hospital, his treatment, his release, his readmission, and continuing treatment, and then his subsequent death? Aren't those all the same thing?
There are relationships, but if it pleases the court, if when Austin Blake was in the hospital, if one of the nurses had slugged him or something, and there was something else that happened, it could be brought in a separate count. And here, the facts are different because, for example,
well, there's no evidence, and I think no suggestion or allegation that somebody slugged him or anything untoward like that happened.
I'm just trying to establish that the mere fact that all of these negligent acts by all of these negligent actors occurred in the hospital setting during the two admissions does not necessarily mean in and of itself that the facts are the same for the purpose of this underwriter's analysis. For example, the relationship between the doctor and the hospital as an actual agent, as an apparent agent, or the existence of a non-delegable duty, none of those facts have anything to do with the Blake's claim against the hospital based upon the actions of the nurses, the hospital staff, the physician's assistant. Those things, the relationship, are different facts. Secondly, the negligence is much different. As the defendant says in its brief on page 4, footnote 2, hospitals cannot perform surgery. They cannot do it. So nothing that happened in the course of surgery or the failure to perform surgery can the hospital be liable for. That's like the nurse coming up and slugging him. That's a different fact than the treatment that was rendered. It's much different. The nurses here, they're liable for things that Dr. Epstein couldn't be liable for. They're liable for failure to evaluate Austin Blake's nutritional status. He was not eating. He had nausea. He was vomiting. He was displaying these signs of this sepsis that they should have evaluated. They didn't take care of the wound while they were watching him, and Dr. Epstein was nowhere around. They allowed his discharge when he wasn't stable. They failed to monitor the IV site. Those are separate acts, separate facts. Dr. Epstein, in addition to not performing the surgery that he should have done to remove this infected vein, he didn't examine Austin before allowing the physician's assistant to discharge him. He didn't examine him after the initial admission at all. Different facts. So that element, I would submit, satisfies the appealability under the universal case. The second factor, whether one or more parties were removed from the action by the order. The court has to look at this in a different way, because if this court, in the Universal Underwriters case, could not have meant that literally, because if one party is totally knocked out of the case, of course that order has to be appealed immediately under Rule 9.110K. Says if a partial final judgment totally disposes of an entire case as to any party, it must be appealed within 30 days of rendition. End of quote, end of story. So if that factor is satisfied, then we don't need to go through this analysis of these other factors. The order has to be appealed. So I'm submitting that what that must mean is whether the...
Doesn't it mean what it says?
It means, but it doesn't, it means it in a different sense, and let me explain.
What is left of the case against Bayfront in the trial court? In other words, if we kept the status quo, what would you go back and do?
Try the case based upon the nursing hospital staff's negligence.
And what would be the basis for liability against Bayfront? In other words, what's the theory?
The nurses failed to monitor the IV site to see that it was getting infected. They failed to document the status so that the doctors, when they come in and checked on him, could see what the status was. They didn't evaluate, as I said a while ago, his nutritional state. He's not eating. He's got nausea. He's vomiting. Something is causing this. They did not adequately document that. They didn't take care of the wound. If they had been taking care of that wound, seeing that it's getting worse, getting infected, something could have been done. Austin Blake was not stable when he was discharged, and the nurses didn't, when they saw he was being discharged, didn't do something. These nurses, they have an independent duty of care, as my co-counsel, who is also a nurse, reminds me very often. So that's all that's left, but nothing that Dr. Epstein did or did not do himself would be litigated. And that's the shame of this, because that will cause us to have to try the case twice. If I could, though, if the court will indulge me to explain how this second factor can be considered here. What I think the court meant in this Universal Underwriters case is not whether the dismissal of one of the total dismissal of one party required an appeal as to that party. I think that means whether the dismissal of one party has something to do with the remaining case against the party that's not dismissed. And here, it does. Here, if Dr. Epstein had been, let's take it this way. If Dr. Epstein had been totally dismissed from the case, okay, I think that would definitely make it appealable as to Bayfront immediately, because the plaintiff claimed for derivative, vicarious liability for Dr. Epstein's negligence. You know, there's this line of cases that when one defendant is dismissed totally from a case, if the co-defendant wants to preserve their rights to put them on the verdict form as a Fabre defendant, the co-defendant has to appeal that immediately. And so that recognizes that when they go to trial with the plaintiff against the remaining co-defendant, the co-defendant that's still on the case has an altered liability. The liability of that co-defendant is altered by the complete dismissal of the other party.
But
we don't have a situation here where anybody's been completely dismissed from the case,
That
correct?
leads me to the next logical step, which is the order here, like an order totally dismissing Dr. Epstein would have been, that order alters the hospital's potential liability. It certainly does on the vicarious, the actual agency and the apparent agency count, because now when we go to trial against the hospital, the hospital is not going to be held liable for those things because it alters the landscape of the remaining defendant's liability, just like the total dismissal of a party alters the landscape of the remaining defendant's liability to the plaintiff. That, in my opinion, is what's meant by that second factor. If it, not that it totally dismisses a party, but if the order has some potential of altering the liability of the remaining defendant to the plaintiff, that's like a total dismissal of that party. It can be immediately appealed. So I would submit that these factors, if they're flexible factors and they need to be weighed and balanced, they need to be weighed and balanced in favor of judicial economy. If it could go either way, we shouldn't have to go to trial twice on an expensive, time-consuming medical malpractice case that's already taken this long. The court should accept the fact that there is jurisdiction. And doing that, I'll turn to the merits here. Here, the dismissal of the count for actual agency, I think it is just patently error. To begin with, because Bayfront conceded at the hearing, and they concede in their brief, that they weren't even looking for dismissal of the actual agency count. If they weren't looking for it, it's not right to make us go to trial twice in this case, especially since there's a count that was dismissed with prejudice that they didn't ask to be dismissed with prejudice. They conceded at the hearing, and they've written in their brief, quote, whether there was an actual agency relationship or employer-employee relationship between Dr. Epstein and Bayfront would be addressed at summary judgment. Only the apparent agency claim is in dispute. They admit it. If they admit that, they say, well, somehow, in a cryptic way, they say count 14 was still dismissed properly. Count 14 included the actual agency claim. And they kind of hint that the reason they're saying that it was dismissed properly is because it was intermingled with the claim for apparent agency. But at the hearing, they made it clear they were only saying the apparent agency claim should be dismissed because it was intermingled with the actual agency claim, not the other way around. Not the other way around. And certainly, even if they had made the argument that the actual agency claim should be dismissed because it was intermingled, it can't be dismissed with prejudice. Cited on page 3 of my reply brief from the 4th District Court of Appeal, the Eagletech case, even though it was improperly pled, it shouldn't be dismissed with prejudice. We should be allowed to go back, and this court should find that there is jurisdiction to order that it go back and go to trial on the actual agency count. The dismissal of the apparent agency claim of count 14, that was error too. The admission and consent form, the only thing really that Bayfront argues on this is that there was no representation by the hospital that Dr. Epstein was acting on its behalf. There were two things alleged in the complaint, and I disagree with the argument that we have to allege the evidence, the specific facts. Here we've alleged two things that would support the representation. The admission and consent form that gave Bayfront the right to collect all the charges levied by Dr. Epstein. That's indication that he's their agent. Also, the admission and consent form says to the patients, look out, don't blame us for every doctor's liability here. In essence, it says that because some of our doctors are employees, not of us, but of the Board of Governors, Board of Trustees. They're university doctors, not our employees. By saying that, by implication, that is that those doctors that are not employees of the Board of Governors, Board of Trustees, are their agents, are their employees. It should survive a dismissal. Next, where the long line of cases involving emergency room doctors is not just because there's a representation that the emergency room is part of the hospital, but where the patient does not have any control over who treats the patient when they come in through the emergency room. The representation is established here, it's dispensed with. Cooker versus Hillsborough County Hospital Authority, cited in our brief. It says that while some of these cases, including Chmielewski, which I finally was able to pronounce, and others, are emergency room doctor cases, apparent agency, the law does not limit it to the emergency department context. In that case, the hospital held itself out as possessing a labor and delivery department. Here the complaint alleges, quote, Bayfront held itself out as a hospital well qualified to provide hospital services. This is the dismissal stage. This is a complaint that alleges sufficient facts to survive dismissal of the apparent agency claim, and it should be reversed. Non-deliverable duty. The duty was assumed by virtue of the admission and consent form. The argument that the decedent didn't sign the admission and consent form should be rejected. He couldn't sign it. He was in septic shock. His father signed it on his behalf. He was acting as his agent. That should be sufficient to establish, at least get around the pleading hurdle of this. And finally, the dismissal with prejudice of the Florida Administrative Code violations should be reversed. We're not trying to create a cause of action for a violation of these code provisions. We're simply pleading those which the law recognizes a violation of a statute or administrative regulation enacted for protection of a plaintiff is evidence of negligence, and a violation can support an instruction. So there's no reason to dismiss those. We're not trying to create a new cause of action. The court has jurisdiction. The court should exercise the jurisdiction. Unless there's any questions, I'll save the rest of my time.
All right. You've got 5 minutes for rebuttal. Thank you, sir.
May it please the court, good morning. My name is Gabrielle Osborne and I represent Bayfront Medical Center. The trial court's decision to dismiss with prejudice counts 14 and 15 of the third amended complaint, actually the fifth version of the complaint in the record, should be affirmed.
Before you get into the merits,
yes,
you want to tell us about jurisdiction? Do we have jurisdiction or not?
Well, Your Honor, we would argue in the alternative. If this court is not convinced by the merits of this case, the court should sua sponte dismiss this claim or this appeal for lack of jurisdiction.
Wait a minute.
Yes, Your Honor.
If we don't have jurisdiction is the first thing that we consider. That's where we begin. Because if we don't have jurisdiction, we don't look at anything else. We don't go any further. So it's not like, we consider the merits and then decide if we have jurisdiction. It's the other way around.
Absolutely, Your Honor. Jurisdiction is fundamental.
All right.
And
so
yes,
since it's fundamental and we're agreed on that, do we have jurisdiction here or not?
No, Your Honor. And so for several reasons we don't. If we actually look at the counts in the third amended complaint, each count at the very beginning of that count reincorporates and realleges paragraphs 1 through 59, which is the same operative facts throughout the entire complaint. More importantly, count 14 for vicarious liability, and we'll get to the problems with that in a moment, and count 15 for contractual non-delegable duty, both rely on the admission and consent agreement. That admission and consent agreement wasn't present for the first admission, but was present for the second admission, and albeit was signed by the patient's father. More importantly, and to address the arguments raised regarding actual agency and apparent agency, that argument actually works against the appellant when it comes to the consideration of the universal factors. Specifically, the third factor, are the counts separately disposed of based on the same or different facts? Well, Your Honors, actual agency and apparent agency are cousins. They're very, elements are very similar in different ways. And specifically at the hearing, the judge and counsel actually conceded that actual agency would be something to challenge at summary judgment. So here, when we're talking about actual agency and apparent agency, the fact that those counts are so, and elements or causes of action are so intertwined, that suggests that jurisdiction shouldn't exist in this case because it would further piecemeal review. In addition, going back to the very first factor, could the cause of action disposed of by partial summary judgment be maintained independently of the other remaining causes of action?
Can I ask a question? Is your friend correct that there is nothing left in the trial court against Bayfront based on Bayfront's liability? This is imprecise, but for Dr. Epstein's conduct.
Well, that's interesting, Your Honor. If you look in the record at count 13 on page 998, which I have here, and it's paragraph 167, this is an allegation that arguably, based on the court's order, still remains in the third amended complaint, and it states, during Austin Blake's hospital admission from February 8th, 2008 through February 13th, 2008, defendant Bayfront's agents, apparent agents, servants, employees, nursing staff, and other medical hospital staff were negligent in their care and treatment of Austin Blake in that day. Then the count goes on to allege a multitude of paragraphs regarding how it is that every person in the hospital created direct negligence. Obviously, this count itself even commingles concept of agency, apparent agency, and borrowed servant doctrines. Those are very specific causes of action, and, Your Honor, this suggests that the count that still remains at issue in the circuit court would result, or hypothetically, in piecemeal review because of the fact that all of these allegations
So is it your position that Bayfront's liability for the conduct of Dr. Epstein, does it remain in the case or doesn't it?
I believe that it does. If you technically look at the order and the paragraphs in the order, count 13 for direct negligence seems to suggest universal liability for every medical staff person, unnamed tortfeasors that exist. So hypothetically, the court, or the plaintiff below, could continue against Bayfront on those claims based on the technicalities of the order itself. In other words, there's no finality here. There is still work for the circuit court to be done, and that goes to the very concept of finality when we look at determining whether there's jurisdiction in a case. And that also fails factors 3 and number 1 of the universal test.
Assume for the moment that we disagreed with you about that and concluded that, that in fact this order did dispose of everything related to the hospital's liability for the conduct of Dr. Epstein. Does it matter?
Well, Your Honor, jurisdiction is certainly important, but what is the issue here is really not the counts of actual agency, apparent agency, and the substantive concepts. If we actually look at the record and what occurred in this case, this is about pleading. And Rule 1.110F regarding what a litigant must plead at the outset of litigation in order to state a cause of action. That particular subsection of the Rules of Civil Procedure requires separate statements. Each claim founded upon a separate transaction or occurrence shall be stated in a separate counter or defense. If we look at count 14, paragraph 186, I believe at 1011 in the record, we mix up again apparent agency, actual agency, borrowed servant doctrine, non-delegable duty. So we have this vicarious liability count that can't result in Bayfront preparing or challenging the appropriate elements of those causes of action. And what warrants dismissal with prejudice of that vicarious liability count, assuming we get through jurisdiction, is the fact that the plaintiff didn't have one opportunity to correct or perfect their pleadings. There are 5 versions of the amended complaint in the record. And Your Honor, the 4th District Court of Appeals in Barrett v. City of Margate was very clear as far as that particular rule of pleading, and that the plaintiff has to set forth allegations succinctly and separately. For example, the court stated it is not permissible for any litigant to submit a disorganized assortment of allegations and argument and hope that a legal premise will materialize on its own. The appellant's convoluted, verbose, narrative-style pleading, coupled with their refusal to comply with either the trial court's directives or the mandate of Rule 1.110b, clearly demonstrates the need for this rule and exemplifies the potential abuse of the judicial process when the rule is not enforced. This wasn't the first opportunity for the appellant or the plaintiff below to fix the deficiencies in their complaint. And Your Honor, it wasn't as if the court didn't give the plaintiff directions as far as what needed to be alleged specific to the apparent agency claim. In the record at the hearing on, I believe, October 2011, this is what the court directed very specifically to the plaintiff at the hearing in the case. Well, they don't want it dismissed because of the nature of the relationship. They want it dismissed because you failed to allege specific facts as to how, in fact, this apparent agency was represented to the plaintiff. In other words, what was said or who said what that led them to believe that there was an agent relationship. That was the court's directive back in 2011. And 4 versions of the amended complaint later, we still don't have separate counts alleging the elements of apparent agency, actual agency, or any other theory to attach vicarious liability to the hospital. And with respect to the general rule that's out there, that a hospital is not liable for the actions of non-employed physicians merely because they have staff privileges to treat patients within a facility. We need to have those specific elements so both the court and the defendants at the outset of litigation can test the appropriateness of those elements. Here, and turning to, again, the apparent agency issue which was discussed, I will say that the cases of Stone, Orlando versus Chmielewski and Coker, which is this court's decision, are all distinguishable. Those are cases that are well beyond the pleading stage. They're dealing with factual issues at that point. Presumably the plaintiffs in the complaints in those cases actually set forth the elements of apparent agency and actual agency so that the court could consider whether or not a sufficient representation, the very first prong of the apparent agency elements, was met by the hospital. Specifically, and to distinguish Orlando and Coker even further from this case, from what you can derive from the commingled and mixed up pleadings. In Orlando versus Chmielewski, that dealt, of course, with emergency room care. But if you look at the vicarious liability counts and the non-delegable duty counts, emergency care and implied contract were issues that were never pled below as a basis for the apparent agency theory. So both the defense and the court is left guessing, how are we meeting the elements of apparent agency? How do we untangle them from the other elements and causes of action of vicarious liability? We want to focus, although the appellant wants to focus on the substantive elements, we're not even to that stage. We're still at the basic pleading stage after 5 versions of the complaint. Furthermore, in Coker and in Orlando, there was a specific finding by the court, and it's in the opinion, if you look carefully through the facts in both cases, that Orlando Regional Medical Center, or the plaintiff in that case, came to Orlando Regional Medical Center because of that emergency room's name and reputation. It's not an allegation that's similarly pled in this case. Furthermore, in Coker...
Can we tell from the pleadings in this case, because I mean that's all we have, was Dr. Epstein in the emergency room and did, I assume at some point, Mr. Blake was transferred into a regular ward. Did he continue to treat him, or was his treatment limited to the emergency room, or how did that work?
Well, actually, Your Honor, that's a very interesting distinguishing point, and I believe it's briefed in our factual portion of the brief, but Dr. Epstein actually didn't see the patient in the emergency room at all. He entered verbal orders. There are actually other physicians, other staff members and agents, et cetera, that rendered care to Mr. Blake at that time. He had been in a motorcycle accident and was brought to the facility. But separate and apart from that, we still need to know that emergency room care or some sort of implied contractual non-delegable duty, whatever the plaintiff wants to call it, is the basis, so that way we can test it at summary judgment. That's why it's so important and so critical that the plaintiff plead out the elements of their complaint.
But it was my understanding that when Mr. Blake was readmitted, somehow Dr. Epstein was still alleged to be involved in his care. I assume when he came back in the second time, he was on a ward of some sort.
Your Honor, and although this goes somewhat outside of the scope, I believe, what's in the record per se, the plaintiff actually came back to, was originally admitted to Peace Regional Medical Center's emergency room, and then there was a transfer requested to Bayfront Medical Center at that point. And again, when we look at contractual non-delegable duty, the admission and consent agreement for that aspect of the care wasn't signed by the patient. It was actually signed by his father. So Dr. Epstein continued to be his surgeon throughout that time frame, but as far as who, what, where, when, why, or how, that really goes outside the four corners of the complaint.
Okay.
Yeah. And going back for a moment to Coker and why this case is, again, different from Coker, this court recognized that Tampa General, which was the hospital in that case, held itself out as being equipped with the labor and delivery department. There's no allegations that Bayfront, other than saying in paragraph 7 that it was a hospital and held itself out as a hospital, which isn't in dispute in this case. There's nothing specific about this emergency room or this trauma facility or this labor and delivery department that says that Austin Blake came there for that reason. That also distinguishes, again, this case from the Orlando Regional Medical Center case from Chmielewski. In that case, it was the emergency room's name and reputation that brought the patient there for care. There's nothing in the record, in the record or in the complaint that suggests that is the basis or the pled basis for Austin Blake receiving care at Bayfront and then also being treated by Dr. Epstein and other medical staff members. Turning for a moment to the administrative regulations in the case. The paragraphs involving administrative regulations were also appropriately dismissed and also raises another jurisdictional issue. Florida Statute 20.42 recognizes and delegates to the department, the Agency for Healthcare Administration, responsibility for regulating and enforcing regulations for health facility licensure. It specifically says, is responsible for the health facility licensure, inspection, and regulatory enforcement investigation of consumer complaints related to healthcare facilities. The allegations regarding administrative regulations do not create a private cause of action that's sufficient to be pled as part of this long and...
Assuming that this case goes forward and those allegations about the administrative regulations are not in the case, would it be accurate to say that the plaintiff could still introduce evidence about violations of those regulations as part of its negligence claims?
Certainly, Your Honor, and they would be subject to the rules of evidence at that point. You know, is there a finding from ACA or the Agency for Healthcare Administration that there was some violation, and can the plaintiff tie that to the damages alleged by the individual plaintiff in this case? You know, it would be subject to hearsay rules and all of the other evidentiary rules, so it certainly could serve as some evidence later on, but to put it in the pleadings and to suggest that that violation creates some sort of negligence just based on the fact that you didn't provide or document the right diet to the individual really steps into the footing and the jurisdiction of the Agency for Healthcare Administration and arguably the Division of Administrative Hearings that would hear any disagreement over whether or not those violations were actually occurred in the case. And Your Honor, the Florida Supreme Court has been quite clear and was clear in Murphy versus Sinha Corporation, 644 Southern 2nd, 983, where there is not an expressed legislative intent in a statute or regulatory provision to create a private cause of action, a private cause of action will not be implied. And Your Honor, in this case, let's also be clear, negligence per se has never been alleged. That is not. Those administrative regulations just became part of the pleading and stand on their face saying that negligence occurred based on this violation. Well, it really doesn't set forth the elements, again, of negligence per se. I would also address the issue of whether or not the contractual non-delegable duty count was actually appropriately dismissed. Again, implied contract was never alleged or argued as a basis for count 15. The plaintiff relies on the admission and consent agreement from the second admission. Again, there is no admission and consent agreement in this case from the first admission. There isn't, if you look actually in the count 15, paragraph 192, record site 1014, it actually relies upon the duty is from that admission and consent agreement. And again, it was never signed by the patient, it was signed by his father. This isn't a situation where he's a minor. It's the father that actually signed the admission and consent agreement. There is no emergency care that's alleged in that count as creating some sort of implied non-delegable duty, and even if there were, the 5th District in Pope clearly recognized that there is no implied non-delegable duty creating hospital liability. Similarly, I would encourage this court to consider the specific distinction when addressing the contractual non-delegable duty claim that it found in Tarpon Springs versus Reth. There is a difference as far as non-delegable duties are concerned between the duty to ensure that services are available and provided by competent personnel in a hospital versus providing non-negligent care. And obviously, Reth addressed statutory non-delegable duty, but it still reiterated the fact that under Florida law, we're not going to just simply create some sort of implied non-delegable duty in this case. And that would also tie into the fact that this particular order that's under review doesn't quite make the requisite showing of finality. If you look at the 3rd paragraph in the order, it still reserves or allows the appellant the ability to address statutory non-delegable duty pending a change in the law from the Florida Supreme Court. So again, that takes us back to jurisdiction. We would argue that the court should dismiss this particular appeal for lack of jurisdiction, but if it does find that there is jurisdiction, we would suggest that the pleading deficiencies support the lower court's decision to dismiss this case with prejudice. Specifically in Barrett versus City of Margate, the court found that while it would be...
Well, not the case, just the portions of it. That's
Yes.
what you mean, right?
Yes, the portion, excuse me. If we look at Barrett versus City of Margate, that involved a pro se plaintiff, and that was a 3rd attempt at pleading. Here we have 5 versions of the complaint, and we would state that substantively, this really isn't about whether or not ultimately the plaintiff can get to the factual stage. It's the fact that there was a repeated refusal to comply with the rules of civil procedures so that the defendant and the court could challenge the elements and examine them under the law.
Look, I might understand that with respect to a claim that repeatedly failed to allege ultimate facts sufficient to state a cause of action. What do we do with the actual agency theory, which I think everybody agrees the facts are there to support it. The problem is that it was just commingled with apparent agency. I mean, what do we do with that? And what's your best case saying a with prejudice dismissal is the proper outcome?
Yes, Your Honor. Actually, this court in Ilgan versus Henderson Properties at 683 Southern 2nd 513 dismissed an actual agency account from an amended complaint with prejudice for failure to sufficiently plead the first element of actual agency.
And again, that was a factual deficiency. I guess what is potentially concerning here is there's no parting of the waves between the parties as to whether or not, at least as I understand it, as to whether or not there are sufficient facts here to find an actual agency at the pleading stage. The defect here is more procedural in the sense that you've got actual agency and apparent agency mushed together in a single count. You know, why don't we allow the actual agency part of that to proceed?
Well, arguably, that is what the court below did. And I will tell you, Your Honor, there's somewhat of a distinction. Counsel for Bayfront at the hearing actually said, we will raise actual agencies and the deficiencies therewith for summary judgment. So it's not quite, the difficulty here is when we try and say, well, what do you have and what don't you have to address actual agency versus apparent agency? We can't even figure out which cause of action under a count called vicarious liability that they're trying to proceed on. It seems like hospital liability has become universal for actual agents, apparent agents, borrowed servants. We need to know who, we need to know what. And arguably, the very first part of that step, before finding out who's our agent, who's our employee, who's our borrowed servant, is telling me which theory you're going to proceed on first, and to do that separately. There was a repeated refusal to comply with the rules, to take a look at what the court was actually requesting the plaintiff to do. And when you have multiple pleadings like this, there is precedent, Barrett versus City of Margate, and although there's no magical number of amendments that leads to a dismissal with prejudice, at the third time a lower court acts well within its discretion to dismiss the complaint for faulty pleading. Your Honor, we would suggest that this court should dismiss the appeal for lack of jurisdiction, or in the alternative, we believe that the trial court's decision to dismiss count 14 and 15 should also be affirmed. Unless there are any questions, I'll conclude my argument with that.
Right. Thank you, ma'am. Mr. Watson, you have 5 minutes left for rebuttal, sir.
Thank you, Your Honor. In response to the argument that we somehow violated the trial court's orders to allege specific facts and all this, there was a reference to what happened back in a 2011 hearing. Well, at that time, we did not have yet a copy of the hospital's contract with Dr. Epstein. This employment agreement was later attached to the amended complaint that was wrongfully dismissed as Exhibit B. So we complied with the trial court's order on that. I'm interested but somewhat confused about the argument that the representation that there's still part of the case remaining against Dr. Epstein. I think the argument should not be accepted for that because she qualified that by saying that somehow there still remains work for the trial court to do, that maybe she wants him to dismiss the rest of that, but there's nothing left of the case, and that I believe makes it an appealable order. And I will just try to make better my explanation about the second factor of that universal three-factor determination of whether an order is a partial final judgment. If Dr. Epstein had been totally dismissed from the case, certainly that second factor would come into play not only on whether we should appeal and had to appeal against him, but also that would make that order appealable as to Bayfront immediately, insofar as the plaintiff's claims for derivative or vicarious liability for Dr. Epstein's negligence. So if his dismissal would make those rulings as to the hospital, which was still in the case, immediately appealable, then why shouldn't it, when the order that didn't dismiss him totally, but still just as effectively stopped our chance of establishing derivative vicarious liability at trial? It's because I think what the court meant, I didn't say very artfully before, and maybe not now, by that whether a party was completely knocked out of the case is not, did that make it appealable as to that party, but did that ruling make it something that needed to be appealed as to the remaining party? In response to the attempt by counsel to distinguish the Chmielewski case and this court's Cooker case that established a parent agency can exist even without an express representation by the hospital of representation, counsel said, well, those cases were distinguished because they, quote, went well beyond the pleading stage. Well, guess what? That means that cases involving no representation by the hospital went well beyond. They survived a motion to dismiss. They went into summary judgment and directed verdict. And I'll just quote from the case, this court's decision in Cooker. Although Chmielewski, Irving, and Webb concern a parent agency doctrine relative to emergency room physicians, we find nothing that limits its application strictly to emergency room settings. And here where you have a case where the patient does not pick the doctor, does not have any control over who's going to render this care, it doesn't have to be an emergency room setting. There's jurisdiction. Certainly the actual agency was improperly dismissed and improperly dismissed with prejudice. Counsel have conceded that. We've satisfied the pleading requirement on the other counts. The court should reverse and spare the parties from having 2 trials and then 2 appeals. Thank you very much.
Thank you both. Sure. All right, we'll take up the next case then, which is Green Tree Servicing